This is
Jeffrey Edward Epstein,
a billionaire financier famous for managing money for other billionaires. A man who owned a private island, trafficking underage girls for the pleasure of his billionaire friends. And of course himself. He had a system, recruiters, fixers, friends, enablers, and every few years the internet asks the same question. Why does it feel like everyone knows, but nobody is accountable? Are we still talking about Jeffrey Epstein? Yes, Donald, we are. With the release of his files, what's inside is messy. Real evidence, repeated rumors, heavy redactions. Everything points to one thing. This wasn't just an operation run by Epstein. Before we talk about islands, names, or theories, we need to talk about paper. Because when people say the Epstein files, what they usually imagine is a leak, a single explosive document with a list of powerful names or some hidden archive that was never meant to be seen. That's not what it is. What you're looking at instead are federal records, real ones, created slowly over years by multiple FBI field officers working the same case across different states and jurisdictions. These files weren't written for the public, and they weren't designed to tell a story. They exist to document a process. Every page in this release belongs to a single FBI case. That case spans multiple years, involves numerous agencies, and includes everything from expense forms and subpoenas to evidence logs, internal memos, and handwritten notes taken during interviews. In other words, these files aren't a narrative, they're the scaffolding behind one. That's why they can feel confusing or underwhelming at first glance. There are no dramatic revelations neatly highlighted for you, no summaries explaining what matters and what doesn't, just raw documentation. Much of it is repetitive and much of it is heavily redacted, and those redactions are the most important things to understand. Nearly every page in this file has information removed under specific federal exemptions. You see the same codes appear again and again. These aren't random black boxes. They correspond to legally protected categories: personal privacy, victim protection, ongoing investigation method, and law enforcement techniques that cannot be made public without causing harm. In some cases, entire pages are withheld, and in others, hundreds of pages are listed in the index but never shown at all. That doesn't mean those pages are empty or irrelevant or even fabricated. It means quite the opposite. In federal investigations, the most sensitive material is almost always the least visible. This is where a lot of public conversation around Epstein breaks down. People look at what's missing and assume it means nothing is there. They treat absence like evidence, but these files don't really work that way. They weren't released to satisfy curiosity. They were released because the law allows certain categories of information to be disclosed and forbids others. These files don't exist to explain themselves or to deliver a clean story. They exist to document a case, how it grew, how it expanded, and how evidence was collected, tracked, and protected as the case became more serious. Tier 1. The Island. Little St. James is a privately owned island located in the US Virgin Islands, southeast of St. Thomas. Jeffrey Epstein purchased the island in 1988 through a corporate entity connected to him. From that point until his death in 2019, the island remained under his control. The island is approximately 70 to 78 acres in size and includes multiple structures, a private dock, and facilities capable of supporting long-term stays and private travels. In federal records, the island is treated as a property asset and a location, not as a symbolic centerpiece. It appears in documents as a destination associated with travel, scheduling, and logistics. It's referenced alongside other locations connected to Epstein, including properties in New York, Florida, New Mexico, and elsewhere. The importance of the island in the case comes from how it functioned as a controlled private environment located within the US jurisdiction, used repeatedly over a long period of time. It was not an isolated or temporary site. It was part of a broader network of properties and travel routes. Federal indictments and later civil filings make clear that alleged abuse connected to Epstein was not limited to the island. The island is one location among several referenced in the records, but it became the most publicly recognized because of its isolation and repeated mention in testimony. After Epstein's death, the island became part of a legal dispute involving his estate. The US Virgin Islands government filed suits, alleging that Epstein operated a sex trafficking enterprise within the territory. The estate later settled negotiations and the island was eventually listed for sale. In summary, the island matters not because it's mysterious, but because it was owned, controlled, and repeatedly used over decades. The files treats it as an infrastructure, not myth. The flights. Travel is one of the most frequently cited aspects of Epstein's case. Flight-related material appears across multiple sources connected to Epstein, including aviation records, border processing data, witness references, and scheduling documents. These records establish movement, who traveled, when they traveled, and where they traveled. What flight records do not establish is conduct. In the investigation records, travel data is used to support timelines and corroborate other forms of evidence. It is cross-referenced with communications, locations, and witness statements. Travel alone is not treated as proof of criminal activity. This distinction is critical because flight-related documents are often misinterpreted as lists of participation or guilt, but in reality they are administrative records that show proximity and timing. Ghislaine Maxwell. Ghislaine Maxwell occupies a unique position in the Epstein case. She is the only major associate of Epstein whose role was formally tested in court and resulted in conviction. In 2021, Maxwell was convicted on federal charges related to sex trafficking and conspiracy based on conduct connected to Epstein's operation. Because of this, Maxwell appears across multiple categories of documents: criminal proceedings, civil litigations, exhibits, deposition material, and also scheduling and communication records. Her significance in the record is not based on social proximity alone. It is based on her documented role as an intermediary, someone involved in recruitment, coordination, and facilitation. Unlike many other names associated with Epstein, Maxwell's presence in the file is consistent, multi-layered, and legally defined. Her case provides one of the few clear points where the justice system established responsibility beyond Epstein himself. The client list. The concept of a client list is one of the most persistent ideas associated with the Epstein case. It refers to the belief that there exists a single document listing powerful individuals who participated in or benefited from Epstein's criminal conduct. According to official statements by the Department of Justice and the FBI, no such incriminating list exists in the released record. A systematic review concluded that the files do not contain a document that functions as a definitive list of criminal participation. But what does exist are names appearing in different contexts: contact lists, address books, emails, schedules, travel records, testimony reference, and litigation exhibits. None of these on their own establishes criminal conduct. However, when the same names keep popping up over and over in contact with Epstein, this begins to paint a picture of who really was involved. In the files, accountability does not appear as a list. It appears as a pattern, overlaps, and corroborated cases. The 2008 plea deal. In 2008, Jeffrey Epstein entered into a plea agreement in Florida that resolved state-level charges and effectively halted a federal prosecution at that time. Under the agreement, Epstein pleaded guilty to lesser offenses and served a limited sentence that allowed him significant freedom. The deal later became the subject of intense criticism and internal review. The Department of Justice Office of Professional Responsibility examined the handling of the agreement, and courts later ruled that the federal prosecutors violated victims' rights by failing to properly notify them during the negotiation process. The plea deal was one of the most consequential moments in the case, not because of what it punished, but because of what it prevented. It narrowed criminal accountability, limited leverage over Epstein, and redirected victims towards civil litigations as the primary avenue for redress. The 2019 arrest. On the 6th of July 2019, Jeffrey Epstein was arrested by federal authorities. He was charged with sex trafficking of minors and conspiracy to commit sex trafficking of minors. The federal indictment alleged that between 2002 and 2005, Epstein recruited and abused dozens of underage girls, paying them and using a network of facilitators to expand the operation. The charges referenced the abuse in multiple locations, including New York and Palm Beach, and described a structural system of recruitment and exploitation. Following the arrest, federal investigators executed search warrants, seized evidence, and publicly requested that the victims come forward. Civil litigation's activity increased immediately, and institutional scrutiny intensified. On August 10, 2019, Epstein was found dead in his cell. His death occurred before trial, eliminating the possibility of testimony, plea negotiations, or direct accountability through the criminal process. From that point forward, the case shifted decisively. Civil lawsuits, estate disputes, and document releases continued, but the central defendant was gone. Prince Andrew. Prince Andrew, Duke of York, is the third child of Queen Elizabeth II and a senior member of the British royal family. His association with Jeffrey Epstein entered the public record in the late 90s and early 2000s. during a period when Epstein was establishing himself within elite social, financial, and political circles in both the United States and the United Kingdom. At that time, Epstein wasn't publicly known as a convicted sex offender. His wealth, private aircraft, and access to powerful individuals allowed him to move freely within spaces that included politicians, finances, academics, and royalty. Prince Andrew's name appears in the Epstein records primarily through witness testimony, photographic evidence, and later civil litigations, but not through criminal charges. One of the earliest and most frequently cited references comes from Virginia Giuffre, who alleged that she was trafficked by Epstein and Ghislaine Maxwell and was forced to have sexual encounters with Prince Andrew. According to Giuffre's sworn statements, these encounters allegedly occurred in London, New York, and on Epstein's private islands. These allegations became central to her later civil case and to public scrutiny of Prince Andrew's relationship with Epstein. A widely circulated photograph taken in London shows Prince Andrew with his arm around Giuffre's waist, with Ghislaine Maxwell standing nearby. Prince Andrew has disputed the authenticity of the photograph, but it remains one of the most recognizable visual artifacts associated with the case. For years, Prince Andrew denied the allegations and stated that he had no recollection of meeting the woman. His position was that he had not engaged in contact with her and that the claims were false. In 2019, following Epstein's arrest and eventual death, media attention increased dramatically and calls grew for Prince Andrew to explain his relationship with Epstein. That same year, Prince Andrew gave a televised interview in which he attempted to address the allegations. The interview was widely criticized for failing to provide a clear explanation and for introducing claims that raised further questions rather than resolving them. In 2020, Virginia Giuffre filed a civil lawsuit against Prince Andrew. The lawsuit alleged sexual assault and battery and argued that Prince Andrew knowingly engaged in sexual activities with her while she was underage. Because Epstein had passed away and because the alleged conduct occurred years earlier, the case proceeded as a civil matter, not a criminal prosecution. Prince Andrew challenged the lawsuit on jurisdictional and procedural grounds, arguing that the court lacked authority and that prior agreements involving Epstein should shield him from liability. Those arguments were rejected by the court, allowing the case to move forward towards discovery and a potential trial. However, in February 2022, Prince Andrew reached a settlement with Virginia Giuffre. The terms were not fully disclosed, but the settlement included a financial payment and a statement expressing regrets for his association with Epstein. Importantly, the settlement included no admission of guilt, and from a legal standpoint, the case ended there. There was no trial, no verdict, and no criminal judgment. Ghislaine Maxwell. Ghislaine Maxwell is the daughter of British media magnate Robert Maxwell and was raised in elite political and social circles in the United Kingdom. She entered Jeffrey's lives in the early 90s after Epstein had already begun accumulating wealth and access, but before he became publicly known for criminal conduct. From that point forward, Maxwell became one of the most consistent figures in Epstein's personal, professional environment. Throughout the 90s and early 2000s, Maxwell appeared publicly alongside Epstein at social events, fundraisers, and gatherings involving politicians, academics, finances, and royalty. At the time, the relationship was described as close, though its exact nature was not publicly defined. See, in the files, Maxwell's role begins to take shape not through headlines, but through patterns. Her name appears repeatedly in testimony and later litigations as someone who facilitated introductions, arranged schedules, and maintained Epstein's social and personal network. Unlike many others associated with Epstein, Maxwell's name appears in connection with recruitment. Multiple victims later alleged that Maxwell actively participated in recruiting underage girls, introducing them to Epstein, and normalizing abuse with Epstein's residents. These allegations were consistent across different accounts and many time periods, spanning locations including New York, Florida, New Mexico, and the US Virgin Islands. In 2005, when local authorities in Palm Beach began investigating Epstein, Maxwell's name appeared in witness accounts, but she was not charged at the time. Epstein ultimately entered a 2008 plea deal in Florida, which resolved state charges and halted a federal prosecution during that period. Following the plea deal, Epstein continued to socialize with powerful individuals, and Maxwell remained largely out of the public view. However, she did not disappear from the records. In 2015, Maxwell became a defendant in a civil defamation lawsuit filed by Virginia Giuffre. Giuffre alleged that Maxwell had falsely labeled her a liar after Giuffre accused Maxwell of abuse and trafficking. The lawsuit became one of the most important document-generating events in the entire Epstein archives. Through discoveries, depositions, and court filings, the case produced emails, testimony excerpts, and references to other individuals that later became central to the public's understanding of Epstein's network. Even though the defamation case was ultimately settled, the materials generated during litigations continued to exist within the legal system. In 2019, after Epstein was arrested on federal trafficking charges, attention shifted rapidly towards Maxwell. Epstein was charged with running a trafficking operation involving dozens of underage girls, and the indictment described the use of employees and associates to facilitate abuse. Epstein passed away in custody in August 2019 before trial, and with Epstein no longer alive, Maxwell became the only remaining figure through whom federal prosecutors could pursue criminal accountability connected to the alleged trafficking operation. In July 2020, Maxwell was arrested by federal authorities. She was charged with multiple offenses, including trafficking of a minor, conspiracy, transportation of a minor, and perjury, based on conduct alleged to have occurred between 1994 and 2004. The indictment alleged that Maxwell actively assisted Epstein by recruiting underage girls, grooming them for abuse, and facilitating encounters. During her trial, the government presented testimony from multiple victims, document evidence, and corroborating material intended to establish a pattern of recruitment and abuse. Maxwell's defense denied the allegations and argued that the witnesses were unreliable and the government's case relied on unproven claims. In December 2021, a federal jury convicted Maxwell on multiple counts related to sex trafficking and conspiracy, and she was later sentenced to 20 years in federal prison. The conviction marked a defining moment in the Epstein case. For the first time, a court formally recognized that Epstein's abuse was not carried out by a single individual acting alone, but involved at least one co-conspirator, Les Wexner. Leslie Wexner is the founder and longtime chief executive of L Brands, the company behind Victoria's Secret, Baths and Body Works, and other major retail brands. By the late 1980s, Wexner was one of the wealthiest individuals in the United States. Jeffrey Epstein entered Wexner's life in the mid to late 1980s, during a period when Epstein was still relatively unknown and had not yet established the global profile he would later acquire. Epstein presented himself as a financial expert with specialized knowledge of tax structures and wealth management. Through this association, he gained access to Wexner's finances and business affairs. In 1991, Wexner granted Epstein power of attorney, giving him broad authority over financial matters. This was an unusual level of trust, particularly given Epstein's limited public track record at the time. Over the following years, Epstein's wealth increased dramatically. He acquired multiple properties, private aircrafts, and access to elite social circles. Wexner was widely described as Epstein's primary client during this period, and Epstein's rise in wealth and status is often traced back to this financial relationship. One of the most significant assets connected to this relationship was a Manhattan townhouse located on the East 71st Street. The property was owned by a Wexner's controlled entity and later transferred to Epstein under circumstances that drew scrutiny. The townhouse became one of Epstein's most frequently referenced properties in later investigations and civil litigations. It appeared repeatedly in victim testimony as a location where abuse allegedly occurred. In the Epstein files, Wexner's connection to Epstein is primarily financial, unlike other individuals whose name appear in social or travel contexts. Wexner's name appears in relations to assets, corporate entities, and control over property. In the mid-2000s, as Epstein became the subject of criminal investigation in Florida, Wexner began distancing himself from Epstein. In 2007, Wexner formally severed financial ties following Epstein's 2008 plea deal. Wexner largely disappeared from public discussion, though his prior role remained relevant in civil litigations and investigative reports. After Epstein's death in 2019, Wexner publicly stated that he had been deceived by Epstein and described himself as one of Epstein's victims, citing financial misconduct and abuse of trust. Civil lawsuits filed after Epstein's death revisited Wexner's role not as an alleged participant in the abuse, but as a central figure in understanding how Epstein acquired wealth, property, and legitimacy. In the records, Wexner presents a different category of individual than those associated through social proximity or travels. His importance lies in infrastructure. He is the figure through whom Epstein gained and sustained financial backing, access to elite business networks, control over major properties, credibility within powerful institutions. Donald Trump We all know who Donald Trump is, a New York real estate developer and a media figure who during the 90s and early 2000s operated within many of the elite social circles such as Epstein. Trump's association with Epstein enters the records primarily through social proximity, public statements, and witness references, rather than through financial ties or travel to Epstein's private island. The two men were known to each other during the early to mid 1990s, particularly in Palm Beach, Florida, where both owned properties and moved within overlapping social environments. Epstein maintained a residency in Palm Beach during this period, and Trump owned the Mar-a-Lago club nearby. Photographs and media reporting from the 90s show Trump and Epstein attending the same social events. These material are frequently referenced in later discussions and are preserved indirectly in the documents ecosystem surrounding the case. In the FBI vault materials related to Epstein, Trump's name appears not as a subject of investigation, but in the context of interviews and background references conducted during the Palm Beach investigation. These records reflect that investigators spoke with individuals who had knowledge of Epstein's activities and social environments during the period when abuse was alleged to have occurred. One documented aspect that differentiates Trump from several other individuals in Epstein's orbit is the timing of the association. A public statement attributed to Trump indicates that he distanced himself from Epstein prior to Epstein's first criminal prosecution in the mid-2000s. Trump later stated that he had not been close to Epstein and that Epstein was no longer welcome to his properties. In the files, this distancing matters because it places Trump's proximity to Epstein largely before the period when Epstein's criminal behavior became widely known to the public. Trump's name does not appear in connection with flight records to Epstein's private island, financial arrangement with Epstein, recruitment or facilitation allegations, civil litigations brought by victim. Instead, his presence in the files functions as a reference point for understanding Epstein's social reach during a specific era. Bill Clinton. Bill Clinton served as the 42nd President of the United States from 1993 to 2001. After leaving office, Clinton remained an influential global figure through the Clinton Foundation. Epstein's association with Bill Clinton enters the records after Clinton left presidency, primarily during the early 2000s. Unlike earlier figures in Epstein's orbit, Clinton's name does not appear in connection with Epstein's financial origins or early rise. Instead, it appears in relation to travel, philanthropic activities, and social proximity during a period when Epstein was cultivating legitimacy through charitable and political access. In the materials connected to Epstein, Clinton's name appears most prominently in travel-related references. These references stem from flight records and associated documentation showing Clinton's traveling on Epstein's private aircraft during the early 2000s. These travel references are frequently cited because they provide verifiable, time-stamped evidence of proximity. In the records, they established that Clinton and Epstein were in the same physical spaces during specific periods. What the files do not show is evidence that Clinton traveled to Epstein's private island, nor do they document Clinton's presence at locations later identified by victims as sites of abuse. In the FBI vault material related to Epstein, Clinton's name appears in interview summaries and contextual references, reflecting that investigators were aware of Epstein's access to high-profile political figures and that this access formed part of the broader social environment surrounding Epstein. Importantly, Clinton is not identified in the release files as a subject of criminal investigation. He is not named as a co-conspirator, defendant, or target in any indictment related to Epstein. In public statements issued after Epstein's arrest and death, Clinton acknowledged traveling on Epstein's plane, but stated that he did so in connection with humanitarian and philanthropic work. He also stated that he had no knowledge of Epstein's criminal conduct and that he never witnessed any inappropriate behavior. Bill Gates. Bill Gates enters the Epstein files late compared to many other figures. His association with Jeffrey Epstein appears primarily in the 2011 to 2014 period, well after Epstein's 2008 plea deal and public designation as a convicted offender. The timing is critical. Unlike earlier association that occurred before Epstein's criminal history was widely known, Gates' proximity to Epstein took place during a period where Epstein was already publicly disgraced and legally constrained. In the files and related document materials, Gates appears through meeting schedules, email correspondence, and references connected to philanthropic discussion. One of the most significant document categories tying Gates to Epstein involves emails and scheduling communication preserved as part of broader investigative and litigation records. These documents show that Epstein sought access to Gates through discussions related to philanthropic, global health, and charitable initiatives. In these records, Epstein positioned himself as a facilitator, someone who could connect wealthy individuals, academic institutions, and philanthropic causes. Gates' name appears in this context as part of Epstein's effort to re-establish relevance and influence after his conviction. Importantly, the files do not show Gates as a financial client of Epstein, nor do they place him in locations later identified by victims as sites of abuse. His presence in the files is limited to meetings and communications, not travels to Epstein's properties or participation in Epstein's operational work. After Epstein's arrest and death in 2019, Gates publicly acknowledged that he had met with Epstein on multiple occasions. He described those meetings as a mistaken judgment and stated that Epstein's involvement did not lead to any philanthropic outcomes. These public statements are consistent with how Gates appears in the files as someone Epstein attempted to engage with during a late phase of his influence, rather than as someone embedded in Epstein's earlier infrastructure. Leon Black. Leon Black's connection to Jeffrey Epstein appears in the documents primarily through financial transactions, professional association, and post-conviction dealings, rather than social or travel proximity. Unlike earlier figures whose association with Epstein predicates his first crime, Black's documented involvement occurs after Epstein's 2008 plea deal, during a period when Epstein was a registered offender and widely known to have pleaded guilty to related crimes involving minors. In the files and associated records, Epstein is described as providing financial, tax-related services to Black, particularly in connection with estate planning and personal wealth matters. These services were framed as advisory work and were conducted over a number of years. One of the most significant aspects of Black's appearance in the Epstein records involves large financial payments made to Epstein after 2008. According to documents later reviewed by investigators and independent examiners, Black paid Epstein tens of millions of dollars for these services over an extended period. These payments became a focal point of scrutiny after Epstein's death, not because they were illegal on their face, but because of the timing and scale. In the Epstein files, financial references and correspondence reflect Epstein's continued role as an intermediary and advisor to wealthy individuals even after his conviction. Alan Dershowitz. His connection to Epstein enters the documented record in the late 1990s and early 2000s, during a period when Epstein was actively socializing with lawyers, academics, and political figures. Dershowitz's name appears in the Epstein files not through financial records or recruitment references, but through litigations, sworn allegations, and legal filings that later became central to public scrutiny. The most significant reference rises from civil complaints and sworn statements filed by Virginia Giuffre. In those filings, Virginia alleged that Epstein trafficked her to several individuals, including Dershowitz, when she was underage. These allegations were made under oaths and became part of the official court record. Dershowitz had consistently denied the claims, stating that he never engaged in misconduct with Virginia and that the allegations were false. Because Epstein was deceased and criminal prosecution was no longer possible, the dispute between Virginia and Dershowitz unfolded entirely within civil litigations. In 2014, Dershowitz filed a defamation lawsuit against Virginia, arguing that her statement accusing him of abuse were false and damaged his reputation. Virginia countersued, maintaining the truth of her claim. These cases generated depositions, affidavits, and extensive legal arguments, all of which entered the broader Epstein files ecosystem. Portions of this material later appeared in unsealed filings and DOJ released document sets, including excerpts that reference testimonies and legal positions taken by both sides. In 2017, Dershowitz and Virginia reached a settlement that resulted in the dismissal of claims and counterclaims. The settlement included no admission of wrongdoing by either party. Jean-Le Brunel. Brunel enters the Epstein records in 1990s, during the period when Epstein was expanding his social and operational network. In the files and related litigation material, Brunel appears in connection with recruitment allegations, witness testimony, and patterns of introductions involving young women and girls. His name does not surface as a peripheral social contact, but as a figure repeatedly associated with how Epstein and his associate identified and accessed potential victims. Multiple victims later alleged that Brunel acted as a recruiter and a facilitator, introducing them to Epstein or steering them towards situations in which abuse occurred. These allegations appear in sworn statements and civil filings, including materials generated during Giuffre versus Maxwell and other related cases. In the early 2000s, Brunel's modeling agency were active internationally, giving him access to young women seeking work in fashion and entertainment. In the files, this professional context is cited as relevant to how recruitment could occur under the appearance of legitimate opportunity. Following Epstein's 2008 plea deal, Brunel continued to appear in civil litigations and testimonies related to Epstein, though he was not prosecuted at that time in the United States. After Epstein's arrest in 2019, renewed scrutiny brought international attention to figures connected to alleged recruitment networks. French authorities opened a criminal investigation into Brunel separate from the US proceedings based on allegations of assault and sexual exploitation of minors. In 2020, Brunel was arrested in France and formally charged. The French case relied on testimony from multiple accusers and on evidence gathered independently of US prosecutors, though the allegation overlapped with those present in Epstein's related files and civil litigations. Brunel was held in pre-trial detention while the investigation continued, and in February 2022, Jean-Louis Brunel was found dead in his cell in the La Sainte prison in Paris. At the time of his death, no trial had taken place and no verdict had been reached. Glenn Dublin. Glenn Dublin is a hedge fund manager and the co-founder of Highbridge Capital Management, a firm that later became part of JP Morgan Chase. By the late 1990s and early 2000s, Dublin was a prominent figure in New York's financial and social circles. Dublin's association with Jeffrey Epstein appears in the documented record through social proximity, residential overlap, and witness testimony references. Dublin's name enters the Epstein record during the late 1990s and early 2000s, a period when Epstein maintained multiple residences in New York and Palm Beach and hosted frequent gatherings involving wealthy individuals, politicians, and associates. In the files and related civil litigation material, Dublin is referenced as a friend and a social associate of Epstein. He and his then wife, Eva Anderson Dubbin, were known to spend time with Epstein in social setting, and Dubbin maintained a residence in the same Manhattan townhouse building that Epstein later controlled. This physical proximity becomes relevant in later testimonies, in sworn statements and depositions preserved in civil litigations tied to Epstein. At least one victim alleged that she was trafficked to Dublin. These allegations appear in the Epstein files as part of a broader testimony describing Epstein's abuse and the environment in which it occurred. Dublin has categorically denied these allegations and has stated publicly that he did not engage in sexual misconduct, that he was unaware of Epstein's abuse of minors, and that any allegation to the contrary are false. Dublin's name appears in context of witness statements, deposition excerpts, references describing the social environment around Epstein. He does not appear as a recruiter, a financial sponsor of Epstein, a logistical facilitator, or an operational intermediary. Virginia Giuffre. Virginia Giuffre is one of the most central figures in the Epstein records, not only because of her allegation, but because of the volume of legal material her action produced. Her presence in the file begins in the early 2000s, when she was just a minor living in Florida. According to her sworn statements, she was recruited by individuals connected to Jeffrey Epstein and was subsequently trafficked to Epstein and others while underaged. Those allegations formed the basis of her later role in the records, but what distinguishes Giuffre from many other victims is how early and how persistent she pursued legal actions. Giuffre first came forward publicly in the mid-2000s during the period when Epstein was under investigation in Palm Beach. At that time, her statements were provided to law enforcement and became part of investigative material that would later be referenced but largely sealed. After Epstein's 2008 plea deal, Giuffre continued to pursue accountability through civil avenues. This decision fundamentally shaped the Epstein archive. In 2014, Giuffre became a plaintiff in civil litigation that named individuals connected to Epstein, including Ghislaine Maxwell. Her defamation lawsuit against Maxwell alleged that Maxwell had falsely labeled her a liar after Virginia accused Maxwell of sexual abuse and trafficking. The lawsuit is one of the most consequential events in the Epstein records. Through discovery, depositions, affidavits, and exhibits, the case generated thousands of pages of documents. These materials included emails, testimony excerpts, and references to other individuals and events connected to Epstein. Even though the lawsuit itself was eventually settled, the documents created during litigations did not disappear. They entered court systems and archive storages. Many of the names, emails, and excerpts that circulate today as part of the so-called Epstein file originate not from criminal indictments, but from Virginia's initiated civil litigation. Tier 3. Recruitment. Recruitment is the first documented step in Epstein's operation, and it appears in a file long before the abuse itself is described in detail. Across FBI interviews, sworn victim statements, and civil litigation filings, recruitment is not presented as a single event or a centralized pipeline. It appears instead as a repeated method applied consistently over time across different locations and through different individuals. The earliest account places recruitment in Palm Beach, Florida during the late 1990s and early 2000s. Multiple victims described being approached as teenagers, often while living in economically unstable circumstances or working a low-wage job. In these accounts, Epstein is not the first point of contact. Instead, recruitment typically begins through another woman who has already been inside the system. In FBI interview summaries and sworn testimonies, victims repeatedly describe being told about a massage opportunity. The work is framed as simple, legal, and well paid. Payment amounts are often described as unusually high for the task being offered, especially given the age of the person being recruited. The files show that this framing was deliberate. Recruitment language emphasized ease, discretion, and normalcy. There is no mention of a point of entry in most accounts. The opportunity is presented as routine, private, and low risk. Once a new recruit agrees, transportation is often arranged. In the files, this pattern repeats across locations: Palm Beach, New York, and later other properties. The setting changes, but the method doesn't. A key feature of recruitment described consistently in the record is payment for referral. Victims stay after first completing a first visit. They were told they could receive additional money if they brought other girls. This mechanism appears repeatedly in testimony and is one of the most important indicators that recruitment was not incidental. Rather than relying on a fixed recruiter, the system incentivized victims themselves to expand the pool. This reduced exposure, diffused responsibility, and allowed the operation to grow without formal advertising. The files show that this method produced predictable results. Victims recruited friends, classmates, or acquaintances, often girls of similar ages and circumstances. This explains why testimony across different cases describes similar age ranges, similar introductions, and similar first encounters. Recruitment also relied on plausible deniability, because initial contact was made by other young women, and because the first visit was framed as a legitimate service, Epstein could maintain distance from the recruitments itself. In the files, this distinction matters, as is one of the reasons why early investigations struggled to identify a clear recruiter figure. Recruitment was not centralized in one person, it was distributed. In later civil filings and depositions, victims described being unaware at the time that what they were entering was illegal. Many state that they did not understand the nature of what was happening until after multiple visits, when expectations escalated. This delayed awareness is consistent across accounts. The files show that recruitment succeeded not because it was aggressive, but because it was incremental. The system relied on youth, trust, and normalization. Recruitment did not end once Epstein became publicly known. After Epstein's 2008 plea deal, recruitment references do not disappear from the record. Instead, they appear in later testimony as historical accounts, describing how the same method had been used for years before intervention occurred. Grooming and normalization. Grooming is the stage that follows recruitment. Once a victim entered Epstein's environment for the first time, the record shows that the experience rarely escalated immediately to overt abuse. Instead, victims described a gradual process in which behavior that would normally trigger alarm was framed as routine. In FBI interview summaries and sworn statements, victims consistently described the first encounter as structured, controlled, and predictable. The visit typically began with instructions that framed the interactions as professional: shoes moved, rules explained, payments discussed up front. The activity itself was initially described as a massage. This framing is one of the most repeated elements in the file. Victims state that the term massage was used deliberately and consistently, creating a boundary that appeared legitimate and non-sexual. The setting reinforced the impression: quiet rooms, controlled environments, rather than chaos. The files show that this first stage served a specific purpose. It tested compliance without provoking immediate resistance. After the initial visit, subsequent encounters often involved slightly expanded expectations, touch that were beyond what had been described, requests framed as normal or expected, payments that increased alongside compliance. Each step was presented as a small adjustment to something that had already been accepted. The files also show that payments played a central role in normalization. Victims described being paid in cash, often immediately after the encounter. In several accounts, victims state that the money created confusion, a sense that what was happening must be permissible if it was being openly compensated. In testimonies, victims described internal conflict rather than immediate refusal. They described questioning whether they were misunderstanding the situation or whether the discomfort they felt was something they expected to overcome. Another recurring element in the file is isolation. Victims described being alone with Epstein during encounters with no other adult present. In later civil filings, victims described how normalization extended beyond individual encounters. They were encouraged to return, they were told they were trusted, they were told they were special. The files showed that grooming was not relying on threats or overt force. Instead, it relied on repetition, predictability, and gradual boundary erosion. This explains why victims' accounts often included phrases describing uncertainty rather than resistance during early encounters. The record also shows that normalization was reinforced socially. Victims described seeing other girls present or referenced, which further reduced the sense that the experience was abnormal. The presence of peers, either directly or through implication, suggested that participation was common and accepted. Staff and assistants. As recruitment and grooming continued, the files showed that Epstein did not operate alone. Across FBI interviews, summaries, sworn victim statements, and civil litigation materials, references appear repeatedly to staff, assistants, and intermediaries who existed around Epstein's residence and schedule. Victims describe encountering staff members who managed access to Epstein rather than participating in abuse directly. These individuals appear in testimonies as drivers, schedulers, house staff, or assistants who facilitated movements, enforced routines, and maintained structure. In the files, this layer is characterized by partial visibility. Staff are present in the environment, but are rarely present during the actual abuse itself. This distinction appears repeatedly in testimony. Victims describe being picked up by drivers, instructed by assistants, guided through residence by staff, but once inside private spaces, they are typically left alone. Victims record that assistants handled scheduling, appointments were arranged through intermediaries rather than directly with Epstein. Changes were conveyed by staff, expectations were communicated indirectly. This structure reduced Epstein's direct exposure while preserving control. No single staff member appears to have full visibility in the system. Drivers moved people but did not manage payments. Assistants managed schedules but did not supervise encounters. House staff maintained properties but did not question who entered or why. Each role handled a narrow function. Victims described encountering different staff performing similar roles. The names changed, but the functions did not. Properties as infrastructure. The Epstein file shows that abuse did not occur in a single place. Instead, it occurred across a network of properties that functioned together as an infrastructure. Jeffrey Epstein maintained residence in multiple locations over decades, including Palm Beach, Manhattan, New Mexico, and the US Virgin Islands. Each location appears in the Epstein file not as an isolated backdrop, but as part of a distributed system. In FBI interviews and sworn testimony, victims described being taken to different properties at different times. The descriptions vary in setting, but the sequence of events remain consistent. Arrival, instruction, isolation, abuse, payment. This repetition across location is one of the strongest indicators that properties served functional roles rather than symbolic ones. The Palm Beach residence appears most frequently in early recruitment accounts. It is often described as the first location where victims were brought, particularly during the late 90s. Its accessibility made it suitable for initial contact and repeat visits involving local victims. The Manhattan townhouse appears in later testimony and civil filings as a controlled, private environment used during Epstein's time in New York. Victims described being taken there during periods when Epstein was residing in the city. The property size and staffing allowed for movement without visibility. The New Mexico ranch appears less frequently, but its presence in testimony is significant. Victims describe being transported there during longer stays, often in conjunction with travel to or from other properties. Epstein's private island appears in the record as one of several destinations, rather than the center of operations. Victims who reference the islands do so in the context of travel and extended stays, not as the source site of abuse. Money and insulation. Money is one of the most consistent forces in Epstein's record. Not because it explains motive, but it explains endurance. Across the investigative files, civil litigations, and post-convictions reviews, wealth appears repeatedly as the mechanism that insulated Epstein from immediate consequences and allowed the operation to persist. This insulation did not take a single form. It appears as legal resources, financial settlements, corporate structures, and access to professional experts. In the files, Epstein is described as maintaining significant liquid assets, complex financial arrangements, and a network of advisors capable of responding quickly to legal pressure. This capability mattered most at moments of exposure. The clearest example appears during the mid-2000s, when Epstein became the subject of criminal investigation in Florida. Rather than proceeding through a prolonged federal prosecution, the case resolved through a plea agreement that significantly limited criminal exposure. The Epstein files also show that financial settlements became a recurrent feature of Epstein's related litigations. In civil cases brought by victims, settlements often resolved claims without trials. These settlements appear in the files as closed matters, frequently accompanied by confidentiality provisions. While the details of such agreements are often sealed, their existence explains why certain allegations never progress to public adjudication. The effect of these settlements is cumulative. They resolve individual cases while preventing the creation of public findings of fact. Over time, this limits the amount of verifiable detail available on the record. The files also show that Epstein's wealth enabled creation of corporate entities that own properties, managed assets, and handled transactions. These entities appear in property records, estate findings, and litigation documents. After Epstein's 2019 arrest and death, financial insulation continued to shape the record. Victims sought compensation through claims against Epstein's estate. The estate established a victims' compensation program which paid claims without requiring admission of liability. Documentation gaps and redactions. As the Epstein file accumulates, one feature becomes impossible to ignore. Absence. Pages are missing, paragraphs are blacked out, entire sections are withheld. These gaps are not incidental, they appear repeatedly and they follow patterns. In the FBI Vault release, one of the most common documents is not evidence, testimony or correspondence, but deleted page notices. These notices specify that material existed, was logged, and was later withheld under defined exemptions. In some cases, the notices indicate that hundreds of pages were removed from a single file set. These removals are not vague, they are numbered, categorized, and justified under formal exemption codes. The record does not hide the fact that information is missing, it documents the removal itself. This matters because it shows that the public archive is not a complete investigative record. It's a filtered output shaped by disclosure rules, victim protection requirements, and jurisdictional limits. And one of the most consistent reasons cited for redactions is the protection of victims. Across DOJ's release and FBI materials, victim-related information is routinely withheld. Names, identifying details, and contextual information that could lead to identification are removed. In some cases, entire witness statements are sealed or summarized rather than released verbatim. Another category of redactions involve third-party privacy. Names of individuals who were mentioned in documents but were not charged or formally accused are frequently redacted. This includes people referencing emails, schedules, contact lists, or testimonies where the role could not be established or where disclosure could cause unwarranted harm. Redactions also cluster around ongoing or unresolved matter. In some files, material is withheld because it relates to investigations that were active at the time of release, or because disclosure could interfere with future proceedings. Even after Epstein's death, the rationale continues to appear, particularly in documents connected to civil litigations or international cooperations. Named victims. Named victims are the smallest category in the Epstein records. Their names appear not because they were the only victims, but because they crossed a threshold that most never did. They entered the public legal records under their own identity. Once a victim's name appears in court filings, depositions, or sworn affidavits, it becomes permanent, can be cited, challenged, dissected, and archived. The permanence is one of the reasons so few names exist. The record reflects this reluctance. Most victims appear anonymously, a small number appear by name, and fewer still persist to cause multiple legal actions. Virginia Giuffre, who we previously spoke about, is one of the most visibly named victims in the Epstein files, not because her experience was unique, but because her legal actions produced documents. The next named victim is Maria Farmer. Maria Farmer appears earlier in the Epstein timeline than most named victims. Her name enters the record in the mid-1990s when she reported sexual assault by Epstein to law enforcement. At the time, her allegations did not lead to prosecution. In the files, Farmer's importance lies in timing. Her report predicates Epstein's public exposure by years. It appears in investigative summaries as an early warning that did not result in sustained action. Annie Farmer. Annie Farmer is Maria Farmer's sister, who also appears by name in the records through sworn testimony. Her accounts describe being abused as a minor and later coming forward as part of legal proceedings connected to Epstein and Maxwell. Her name appears appears in trial testimony during Maxwell's prosecution. In the files, Annie Farmer's presence demonstrates another pathway by which names enter the record. When a case reaches trial, anonymity becomes harder to maintain. Witnesses may testify under their real names, and transcripts become part of the official court record. The files make one thing clear: named victims are not representative of the full scope of harm. To represent those who reported early, pursued legal action, testified publicly, or were required to appear by name in court. Most victims did none of those things, not because the experience were less real, but because the cost of visibility is documented elsewhere in the archive. Named victims are cross-examined, their timelines are dissected, their memories are challenged, and the record shows this repeatedly. Named victims only in civil filings. Beyond the smaller number of widely recognized names, the Epstein file contains another category of victims whose identities appear only briefly and then disappear. These are individuals whose name entered the public record through civil litigations, not criminal prosecution, and only for a limited window of time. In the files, this distinction matters. Civil lawsuits operate under different rules than criminal cases. Plaintiffs may choose to file under their real names, initials, or pseudonyms. They may later request sealing, withdraw claims, or settle disputes in ways that remove their identity from public view. The Epstein record reflects all of these outcomes. In several civil cases connected to Epstein, victims initially filed under their own names. These names appear in early docked entries, complaints, or exhibits. In some instances, they are referenced in motions, affidavits, or discovery material. Then the trial stops. Subsequent filing replaces names with initials. Entire exhibits are sealed. Case captions change, settlements are reached, and the public record closes without a verdict. The files preserve evidence that these victims existed and participated, but not always their identities. The pattern appears repeatedly in civil litigations, especially cases involving sexual abuse. Courts often balance transparency against harm. Judges may grant motions to seal identifying information to protect victims from retaliation, harassment, or lifelong exposure. As a result, the archive shows partial visibility. A victim's name may appear in one document and be redacted in the next. A sworn statement may be summarized rather than reproduced. In some cases, victims choose anonymity from the outset. In others, anonymity followed public exposure. Unnamed victims. The largest group of victims in the Epstein files has no name. They appear instead as placeholders, Jane Doe. These labels recur across FBI summaries, DOJ findings, civil complaints, and sealed exhibits. In the Epstein files, anonymity is the default. Unnamed victims appear most often in criminal investigation materials, where protecting identity is mandatory. VI interviews summarize allegations without revealing names. Locations are generalized, and identifying details are removed or replaced. The result is a record that describes events without fully situating the people involved. In these files, victims are often identified by age range, approximate year, general location, relationship to other victims. Names are omitted entirely. This does not reduce credibility. In many cases, anonymity increases evidentiary value, allowing testimony to be preserved without risking further harm. In Epstein's archive, these anonymized accounts are not isolated, they are repetitive. Victim A's account resembles Victim C's. Victim B's timeline overlaps with Victim F's, different labels, similar structure. This repetition is one of the strongest indicators of systemic behavior in the record. The file shows that unnamed victims often describe similar recruitment language, similar first encounters, similar payment structures, similar escalation. Even without names, the patterns align. In the DOJ and FBI material, anonymity also allows investigators to cross-reference accounts without exposing identities. Internal notes may link multiple victim statements to the same locations or time frame while preserving confidentiality. To the public, this looks like abstraction, but in reality, it's a documentation constrained by law. Another feature of this category is age designation. Victims are frequently identified as minor females, juvenile, or underage victims with no further detail. This language appears consistently across files and is one of the reasons the record feels clinical. The system records harm. But it does not narrate it. In civil filings, unnamed victims may appear as Jane Doe. These designations allow lawsuits to proceed, protecting identity. However, even here, details are limited. Exhibits may be sealed, testimonies may be summarized, names remain hidden, even when allegations are serious. This anonymity persists over time. Many victims who testified in the early 2000s still remained unnamed in files released decades later. The passage of time does not guarantee disclosure. The file makes this clear. Anonymity is not temporary, it's often permanent. Victims who never filed anything. Epstein file contains repeated acknowledgement of victims who were never identified, never named, and never represented by any formal complaint. They exist in the record only indirectly. In FBI summaries, DOJ disclosures, and investigative notes, references appear to additional victims, other minors, or unidentified individuals whose experience were known to other investigators but never formalized into testimony or litigation. These references are brief, they're rarely expanded, and they're often followed by silence. This absence is not accidental. The file shows multiple structural barriers that prevent victims from ever filing anything, and one of the most common barriers is time. Many victims were minors at the time of the abuse and did not understand what had happened to them until years later, and by the time awareness emerged, statutes of limitations had expired, eliminating the possibility of criminal prosecution or civil recovery. In some documents, investigators explicitly note that allegations could not be pursued due to elapsed time, even when accounts were considered credible. Another barrier is fear. The files reflect that victims often express reluctance to come forward because of Epstein's wealth, connections, and reputation. In interviews, some victims stated that they believed reporting would lead to retaliation, disbelief, or personal harm. The fear was not abstract. The records show that victims who did come forward were challenged aggressively, subjected to legal scrutiny, and in some cases publicly discredited. For others, this served as a warning rather than an invitation. Some victims also never filed because of trauma. In investigative summaries, this appears as notes indicating that a potential witness was unwilling or unable to continue. These notations are brief, but they are recurring. Another category includes victims who reported informally but declined to sign sworn statements or pursue legal action. Their actions may appear in internal notes or investigative leads, but they do not progress into filings that generate public records. As a result, they experience only as references, not cases. In some material, investigators explicitly state that they believe additional victims exist beyond those who came forward. These statements are not estimate, they are acknowledgements of incomplete visibility. The record does not quantify these victims, it does not name them, and it does not narrate their experience. It simply notes that they are there, and then moves on. Tier 5. Epstein's death. Jeffrey Epstein was found unresponsive in his cell at the Metropolitan Correctional Center in Manhattan, New York, on the morning of August 10, 2019, is uncontested in the record. According to Bureau of Prison documentation and DOJ statements, Epstein was discovered at approximately 6:30 a.m. by correctional staff during morning rounds. Emergency response procedures were initiated, and Epstein was transported to New York's Presbyterian Lower Manhattan Hospital, where he was pronounced deceased. The official cause of death, as ruled by the New York City Office of the Chief Medical Examiner, was suicide by hanging. That determination appears consistently across medical examiner documentation, DOJ public statements, and Bureau of Prison reporting. The record confirms that Epstein died while in federal custody, housed in a special housing unit due to prior safety concerns. Epstein had been placed on watch after an incident in July 2019, then later removed from suicide watch and placed on administrative segregation, a status that still required enhanced monitoring. This transition is documented in the Bureau of Prison records and later examined by the DOJ office. The medical examiner's report describes injuries consistent with ligature hanging. The ruling was made following autopsy and investigation conducted under the authority of the City Medical Examiner's Office. However, the record also reflects that independent medical experts retained by Epstein's family distributed aspects of the finding, citing fractures they argued were more consistent with homicidal strangulation. These dissenting opinions were publicly acknowledged, but they did not alter the official ruling, which remained suicide. The Epstein file shows a formal autopsy, an official ruling, a documented disagreement, and no revision of the cause of death. And most important of all, no criminal charges related to Epstein's death were filed against any third party. The prison failures. Jeffrey Epstein died inside the Bureau of Prisons facility. What followed was not a single failure, but a documented breakdown across multiple safeguards that were designed to operate independently of one another. The official records does not frame these failures as intentional acts. It documents them as a procedural collapse. According to the Department of Justice office, Epstein had previously been placed on suicide watch after an early incident. His status required heightened observation and specific housing conditions. Before the night of August 9th to August 10th, 2019, Epstein was removed from suicide watch and placed in a special housing unit cell under BOP policy. The status still required regular checks and supervision, though less intensive than suicide watch. The files do not indicate that the required safeguards for recent removed suicide watch inmates were fully implemented or consistently followed. The DOJ's report documents that 2 correctional officers assigned to the unit during the overnight shifts were working extensive overtime. One officer had worked multiple consecutive shifts and the other one was assigned duties outside their usual role. These staffing conditions matters because BOP's procedure relies on redundancy. Even if one safeguard fails, others are supposed to compensate. Under BOC's policy, inmates in Epstein's housing status were required to be checked at regular intervals. These checks were not optional, they were mandatory, and according to DOJ's findings, the required checks were not conducted as schedules. The records show that officers failed to perform physical rounds, quiet documentation was falsified after the fact, and no timely intervention occurred. These facts are not inferred, they are established through internal reviews and sworn admission. At the time of his death, Epstein was housed alone. The DOJ report confirms that his cellmate had been removed prior to the overnight period, leaving Epstein without the mitigating factors of shared housing. BOC's policy often treats shared housing as a protective measure for an at-risk inmate, but this was removed from Epstein, which raises questions. The files do not show that a replacement cellmate was assigned or the alternative safeguard was increased to compensate. This also raises more questions. Why were all these safeguards mitigated and removed? Video surveillance is another independent safeguard. According to DOJ's documentation, cameras covering the common area near Epstein's cell were not functioning properly the night of his death. Convenient, the footage that would have shown movement in the cell was unavailable. The record does not state that all cameras in the facilities were down, only those relevant to reconstructing activity outside of Epstein's cell. Curious. This matters because video review is a standard component of incident reconstruction. Its absence limits verification of timelines and actions, therefore limiting accountability. Following internal investigation, the DOJ charged the 2 correctional officers for falsifying records. Those charges were later resolved through deferred prosecution agreements, which included community service and compliance requirement. No charges were filed alleging homicide or conspiracy. The official finding stops at procedural failure, but the record establishes. Taking everything together, the files confirm the following. Epstein was not under suicide watch at the time of death. Mandatory checks were not performed. Staffing conditions were substandard. A cellmate was not present. Relevant camera footage was unavailable. Documentations were falsified. Each all happened in the night Epstein took his life. The missing or withheld footage. One of the most persistent feature in the Epstein record is not what it shows, but what it does not. In the aftermath of Jeffrey Epstein's death, multiple official statements confirmed that surveillance cameras existed within the Metropolitan, existent within the prison. These cameras were start-off standard prison infrastructure intended to monitor common areas, corridors, and unit entrances. The record establishes limited but specific. According to the Department of Justice office, a camera position to cover the special housing unit tier where Epstein was housed did not produce usable footage for the period surrounding his death. The reason given was technical malfunction. The OIG report states that cameras outside of Epstein's cell had experienced issues prior to the night and were not recording properly at the time. As a result, there was no video recording showing who approached Epstein's cell when checks occurred. This absence is confirmed in official documentation. What the files also establish is that some footage existed elsewhere in the facility. Cameras in other areas of the prison continued to function and portions of surveillance videos were reviewed internally during the investigation. This camera footage was later released to the public, and when the footage is reviewed, you can see the camera covered the common area of the prison, only showing little details leading up to Epstein's death. The footage was released as the fully raw file, but when examined, you can see the footage has been tampered with. The OIG report further notes that the Bureau of Prison did not present a potentially relevant video recording immediately after Epstein was found unresponsive because footage is routinely overwritten after a fixed retention period. Any recording not promptly secured or permanently lost. On further review of the video forensic expert found multiple evidence detailing that the video had been tampered with. There was many inconsistencies in the video, and the video showed Jeffrey Epstein's final moment when walking towards his cell, but it never showed him actually entering his cell.